podcast, part 3 of biggest mistakes people make in responding to interrogatory. And I kind of really enjoy this series because I've always felt that the more time that my law firm can not devote to this activity of responding to interrogatories, the more time we can devote to more important things in the case, like interviewing witnesses, devising strategies, going through potential deposition outlines with our clients. This is where you really want to be spending most of your time and most of your energy in a case. It's not really answering these idiot questions, and we're going to take a look at some of these idiot questions that defense lawyers like to throw out, and why they're stupid, and why you have to have a good working relationship with your lawyer throughout this process, and particularly during interrogatory and discovery demand responses. Otherwise, you are going to be spending lots and lots of time and many, many hours on things that you don't need to. One of the things that you should do before you start answering the questions, and we talked about this in the first podcast in this series, is having the theme. There's something else you should do. And we do this for our clients. I go through the interrogatory questions and the discovery demand questions, and I eliminate a number of them on objections. Now, obviously, you have to kind of do this for a living to know what objections are good, what are not. Here's a list of some of them. The first one, this is subject to the attorney-client privilege, subject to work product. Typically, you'll get a question, well, tell us, who are your witnesses going to be at this trial? Well, interrogatories, these are generally at the beginning stages of litigation. We don't know that. I don't know the answer to that question. And aside of the fact, you don't have to disclose that. That is a work product or trial strategy immunity. What happens at a trial is there's a pre-trial conference. It's usually a month or two before the trial, and the judge is going to make each side put together a pre-trial statement. And that statement is going to have who the witnesses are. And then the judge will entertain objections at that point as to who the witnesses are. But you should never, ever put down who your witnesses are in an interrogatory response. You don't know the answer to that. You don't know what witnesses will materialize that may help your case. You don't know who's not going to be a witness or who will move to some other state or country that you can't find, and you don't want to be held to what you've said in interrogatories about who your witnesses are. Another one, the objection as the burden or expense of the proposed discovery outweighs the likely benefit. Meaning, this is a stupid question or demand because what do you get out of this? Classic question, and you can see it right here. Please identify your national origin to include your place of origin, the place of origin of your ancestors, including each parent and grandparent, and the particular physical, cultural, and linguistic characteristics upon which you base your national origin identification. Folks, this is not Nazi Germany, okay, where there were trials to prove what your national origin actually was. If someone says, my last name is Garcia, and the person identifies as a Puerto Rican or Hispanic American, that's it. Okay, he doesn't have to do anything more than that. He doesn't have to demonstrate that he really was from Puerto Rico. There may be one person in a million. I remember a number of years ago there was a woman who was white. She was the head of an NAACP chapter out in Oregon or something like that, and said she was black. That's not the typical person. I mean, you're talking about one screwball out of hundreds, thousands, millions of people. Generally, if you're Hispanic American and you say that, you don't have to go ahead and prove that. We're not going to have a trial and call your grandfather, as basically this interrogatory asks you to do. I mean, think about that. We're now going to call the elder Mr. Garcia. You're 97 years old. Where are you from, sir? That doesn't happen, okay? And this question is just a classic. Either the lawyer on the other side doesn't know what the hell he or she is doing, or more likely than not, they know what they're doing and they just want to drive you crazy and waste a lot of time. So this is the type of thing that a lawyer will identify before you ever get this question, and will simply tell you, yeah, number 5 or whatever number it was, don't answer that. It's a stupid question and don't spend any time on this. Here's another one which is so paramount, and I have each of my clients who is going to be responding to interrogatories, which is 95% of any client, to watch these podcasts beforehand. So important. This question, this is another classic question right here. Identify the fact of each incident comprising your hostile work environment claim. Goes on and on and on. Okay, so the first question is, whoa, I suffered from a hostile work environment for 9 months. Things happen to me on a daily basis. You're telling me I have to write basically a book, a small book, a 30, 40-page book of every single fact that happened to me in this thing? I really have to do that? That could take weeks. This is why people are scared to death of doing these things. It's like anything else. You get some big assignment, you don't really want to do it. You kind of put it in the back of your room. I remember this from like the college days on some of these courses I took, which were just requirements and music appreciation, or like, really, it's on the schedule. You got to do this. Ironically, I got an A in that class. But at the end of the day, these are not as hard as they look if you know the rules to these things. So, no, you don't have to write every single fact. There's a standard objection to that, which we can flash right here. It's just basically you don't have to answer all facts, just the material ones, just the ones that really move the needle in your case. And generally what will happen is the defense lawyer is going to challenge you. Certainly if you're unrepresented, the defense lawyer is going to make a motion to the court and say, oh, this isn't good enough, so on and so forth. Usually you'll win that. The other thing on this question, and I get this all the time, and I see clients doing this, and I just want to say, why would you do this? This just takes a lot of time. Don't do this. People rewrite their affidavits that they handed in to the EEO investigator or to the EEOC. You don't have to do that. You just basically say CROI pages 235 to 248, questions 14 to number 22. Meaning, Mr. Idiot Defense Lawyer, this has already been answered. I've already explained this 17 times. I don't have to rewrite this whole thing again. And you shouldn't. All you got to do is find the pages in the ROI where you've already answered these questions and just refer them to the defense attorney. If you're not a federal employee, you have written a whole story about your case to the EEOC. You should have at some point. And in the intake interview, the investigator is going to ask you some questions. You already have this on your email. You know the story here. So you don't have to start from scratch and rewrite this thing again and again. Finally, I'm going to say a word about documents. And it's very simple. You're going to get a bunch of document demands. And here's what I tell my clients. I just tell them, do not be what I like to call the Bud Light real man of genius. I used to love those commercials. Today we salute you, Mr. Document Withholder at the discovery response stage. And we've had clients come to me a few weeks before the trial and tell me something like, Mr. Fischer, I have some documents in this case that will just break this case wide open. And it's like, well, here's the thing, guy. The time for turning those over is already done. You had to do it in the discovery stage. So if you didn't do that, unless there's something you just got, but if you've been hiding these documents in your garage since the beginning of the lawsuit and you want to spring them on a trial, no, you can't do that. Too late. So I tell clients to please search every database, shoebox, basement, garage, anywhere they have a file, documents relating to your case. Turn them over to me. I can decide do you have to turn them over or not, but just turn the stuff over. I think the 3-part series ends here, and I think that if you follow the things on each of these podcasts, you will see this is not an insurmountable task. This is something that you know the rules, you know what's expected of you, you get this done as soon as you can, and then you sign the interrogatories, you produce whatever documents you have to, you're done with an intrusive, what is to some a very difficult part of the case, and you move on to your deposition and you move on to more interesting, productive things like helping your attorney identify witnesses, go through their documents, things that are going to move the needle and get you either a win or a nice settlement or increase your chances of doing either of those two things. If you have been the victim of some sort of wrongful termination at work or hostile work environment or something like that, call our office. Or if you're in the middle of litigation, call us. We can help you.